Thank you everyone for your patience. We will now start the recording and the webinar.
Morning, everyone. Thank you for taking time to join us today. My name is Jessica Evans, and I'm with the Housing Accountability Unit. And with me today is my colleague, David Ying. So today's webinar is the public review of HCD's draft Streamlined Ministerial Approval Process Guidelines update. We refer to this as SMAP for short, so you'll hear me saying that throughout today's presentation. Also with us today is Harrison Annixter, who is part of our data and innovation team, and he'll be providing a quick presentation on the updated SMAP determinations based off of the latest APR data received. And he'll be providing that presentation after I provide a brief overview of the guidelines update. We are recording this meeting, so once the video is available, it will be posted to our webpage. David has left some links in the chat. And the one that says webinars and workshops is where this will get posted. So you can check back there for the recording link, which should be posted in a few weeks. So first, I'll spend a few minutes on this slide talking about today's webinar. HCD is doing this webinar because we've prepared a draft update to the SMAP guidelines. And the expectation is that you've come prepared after reviewing the draft guidelines that have been available for public review for about 2 weeks now. And what we're really looking for today is your feedback on the update so that we can consider the feedback and see how we can make improvements so that these guidelines can be a helpful resource when it comes to actual implementation of the law. We can't clarify something if we're not aware that it's an issue. So we're interested in what you're seeing play out when implementing the law at the local level. What can you put on our radar that is within the scope of the guidelines? With that goal in mind, what does this webinar include? First, it includes a high-level overview and orientation of the SMAP guidelines. In addition, and really above all else, it includes an opportunity for you to provide verbal public comments to HCD regarding the draft guidelines. And the importance of this is reflected in the fact that we are reserving most of our available time for that purpose. Whether all of that time gets used or not, we'll see, but we are creating space for that. So really what we're asking you to do and think about is, what do you want HCD to hear about implementation of SMAP, such that HCD can then go back and consider things to include or change. And then after we provide an overview of the SMAP guidelines update, again, Harrison will present on the updated SMAP determinations. So with that said, what does this webinar not include? This is not going to be a comprehensive training or a deep dive into the law or the updates. David will cover a few slides with an overview of the main components of the law, but that's the extent of it for today's session. However, we definitely encourage you to read the guidelines as a way to familiarize yourself in more detail. And for those who aren't as familiar with SMAP, you might be interested in taking a look at HCD's SMAP Housing Law Fact Sheet, which is also linked in the chat that David posted. But we simply can't cover everything today, and this is not designed as a training. In addition, this is not an opportunity to get on-the-spot technical assistance from HCD on individual or hypothetical SMAP questions related to development projects. For that, you can use our Housing Accountability Unit portal. That link is shown on the screen, and David's also posted that in the chat. If you use the portal to submit a question, an analyst will be assigned and they can properly intake and evaluate the request and the specific circumstances using a process that we have in place for that purpose. Lastly, along the same lines, this is not an extended in-depth Q&A session for the SMAP guidelines update. However, if you do have questions for Harrison related to the updated SMAP determinations, you can direct those questions to him via the Q&A function or by raising your hand when that time comes. You'll notice there is a Q&A function available. You might have already started using it. Please do not use that for providing public comments related to the guidelines update. It is best suited for more minor questions that lend themselves to brief answers, and we'll do our best to try to answer questions intermittently throughout the webinar. And if there's things that we're able to easily address today, we're going to aim to do that. And if we do answer a question, you'll see the question and answer appear in the Q&A box. If there's any questions that we can't answer today, they will be available to us after this webinar, so we'll take a look through them and provide any necessary follow-ups. So hopefully that sets the table for what to expect today, so we can get started. So in terms of the public review process we're doing, here's a quick recap. We posted the draft guidelines on June 18th. So today's webinar is just about midway through that 30-day public comment period. We will continue to collect comments through July 20th. So whether you've already read the document from front to back or you're opening it for the first time today, there's still opportunity to review and share, and today is just one avenue for doing that. If it turns out we will be making substantive changes to this initial draft, then we may do a second public review period, but we can't make that determination until we complete this first round process. So this is your opportunity to help shape the guidelines. We're really relying on your feedback to help make these guidelines as useful as they can be. And we'll be compiling and reviewing all of those comments through this process. A summary of those comments and our responses will also be published with the updated guidelines. So why guidelines? First of all, why are we doing guidelines and who and what are they for? So when the legislature passed SMAP in 2017, they granted HCD with the authority to create guidelines. And with this, HCD was given permission to issue guidelines that, quote, supplement or clarify the terms, references, or standards that are set forth in statute. For reference, the specific language in the law about this is noted on the slide in orange. Although the guidelines and this webinar are for anyone interested, the main users are for those that are implementing SMAP and other housing laws firsthand. Namely, that would include local government staff and consultants that they might be working with, and housing developers and their teams, including land use attorneys. And the intention of these guidelines, again, is to provide clarifications that help address common areas of confusion in the statute that make it harder to implement. Because ultimately, that means that those housing developments are taking longer to move through the review process because of these sticking points that come up, which has the effect of undermining the intent to streamline these projects and facilitate housing for compliant developments. So all in all, the guidelines are envisioned to support more effective and consistent implementation of the statute throughout the state. In terms of outcomes based on APR data received, since SMAP went into effect in 2018, over 43,000 units worth of SMAP housing have been submitted to jurisdictions for review. Within that, almost 28,000 units have been issued planning approvals or entitlements. And for a SMAP project, on average, it gets approved within 121 days versus 283 days for a non-SMAP project. So HCD's hope is that the update to these guidelines will help support an increase in those numbers, which ultimately means more housing to help address the state's housing crisis. So what are guidelines in the first place? So guidelines are unique because they have actual regulatory authority. And that ties back to the previous slide and the language in the government code granting HCD guidelines authority. With that said, it's very important to keep in mind that guidelines do not create new statutory provisions, and HCD is not the legislature. So again, remember, they are only meant to supplement or clarify the law as it's written. So this can include things like rephrasing, elaborating, reorganizing the statute, or providing supplemental tables. It's intended to bring more meaning and clarity to the words on the page and serve as a companion document to the statute. And in terms of clarifications, we're talking a range when it comes to the level of significance. Some clarifications are going to be really minor, and it's more about making the information easier to digest, whereas others are more significant, where we're doing more of the elaborating or supplementing. So here's a quick example to illustrate what I'm talking about. This is an excerpt from the guidelines. It says that a project may receive a one-time, one-year extension. So most of the text in black mirrors the statute, but the red underlined text is new language as part of the update, and it clarifies that a local government can grant additional extensions, but are not required to. And that text in red, again, is not in the law, but it does, and the guidelines here clarify this provision. Most of the round of updates address the several bills that have passed since the last update to the guidelines in 2021. And a lot of the updates include the incorporation of policy determinations made by HCD via technical assistance provided to local governments and applicants. And something to be aware of, at the end of each section of the guidelines, you'll see a little blurb like this one on the screen that notes the authority and references cited in the corresponding section of the document so that you can be aware of what parts of the statute these sections are relying on. So now I'll pass it on to David, who will provide some additional background on SMAP.
Thank you, Jessica. So let's talk about what SMAP is and what it does. SB 35 took effect in 2018 after being signed into law in 2017. And since then, there have been several amendment bills that have made further changes to the original version, the most notable of this being SB 423, which expanded SMAP into the coastal zone, updated the labor provisions, and updated the methodology, or the way that SMAP determines for jurisdictions to not only include unmet RENA, but also not have a housing element in compliance. In this regard, SMAP was the first of its kind, creating a streamlining pathway for qualifying multifamily projects, and other laws have done similar things for other types of projects since. So, as a snapshot of some of the key pieces of the law first, the law can only be used for multifamily projects, and for affordability, a development has to meet the minimum 10 or 50% requirement, depending on the jurisdiction and HCD's determination, which we'll get into after this presentation. There are also site-specific requirements that a project has to meet in order to qualify for SMAP. For example, not having any wetlands on the site, not being a hazardous waste site, or not having any sensitive habitat on site. Qualifying projects that meet the site-specific requirements are exempt from CEQA and are eligible for a streamlined review process. For projects with 150 units or less, a local government has to act on an application within 60 days from the date of application submittal. For projects with 150 or more units, it's 90 days. There's extra time allotted for projects that are subject to design review. There are also additional requirements, including most notably tribal consultation. Application for SMAP can't be accepted until tribal consultation is completed. And finally, there are a host of labor-related standards laid out in the law, and these are included in the guidelines themselves. And note that HCD does not have purview over labor standards. Anyway, back to Jessica.
Thanks, David. So now let's get into the actual draft guidelines. You can think of this as an orientation to what you're going to find. If you'd like, you can follow along by opening up the draft guidelines, and the link is on the screen, which is kind of long, so you can just refer to the link that David's dropped in the chat as well. So here are the draft guidelines at a glance. This is a snapshot of the contents, and the content largely remains the same. You can see there's a new section under Article 3 for subsequent, or what we call also known as post-entitlement permits. And there's also two new appendices at the end. One is for links to the Department of Industrial Relations for labor requirements, and the second appendix is for links to HCD resources. Since these are existing guidelines that are being updated, you'll notice throughout the draft document that text to be deleted is shown as being struck out, and any new language is in red and underlined. So in Article 1, it sets the table for what guidelines are, what they do, and how they apply. Most of all, Article 1 includes definitions, the majority of which are from the statute. And just to reiterate, the purpose of today's webinar is to just collect comments. So I'll just be going over briefly the more notable updates in each article of the guidelines. And so with that, in terms of sample clarifications, we are clarifying in section 100 to remove the repeal date of the guidelines to say that the guidelines will remain in effect as so long as the statute is in effect. There's some updates to the definitions, but the more notable one includes defining site or project site to mean the legal parcel or parcels proposed for development, including any parcel or parcels in which development is occurring on or proposed. Article 2 goes over the methodology and the determination process for the level of affordability that a jurisdiction is subject to. Most of Section 200 is updated and matched the statute. But there is one clarification to note that states that the status of the date the notice of intent in the form of a preliminary application is submitted determines whether an application is subject to SMAP, and also determines which level of affordability applies, either the 10, 20, or the 50%. Article 3 covers the approval process and includes the local government's responsibility in processing an application, including application intake and tribal consultation, and the review and approval process, which includes details regarding statutory timelines to act on a project. And the new addition to this article, Section 302, which addresses the requirements in processing subsequent or post-entitlement permits. Some key clarifications in Article 3 include, first off, in Section 300, we clarify that the notice of intent only acts as a form to initiate tribal consultation, but it does not act as a preliminary application pursuant to SB 330. If an applicant wants to submit a notice of intent and a preliminary application, they must state so explicitly to the local government. Another clarification is that all departments that are responsible for issuing any permits related to the proposed project, including but not limited to tree permits, must also comply with the review timelines that are outlined in SMAP. And lastly, for subsequent permits, in the event a project applicant must obtain any off-site improvement permits from a neighboring city or county, that city or county must also review the permit against objective standards and comply with the statutory timelines for issuing a subsequent permit. And for Article 4, most of the updates mirror the statute, but some clarifications here include making it clear for builder's remedy projects that a project is considered consistent with all objective standards, including design review standards for the purposes of processing a SMAP application. Secondly, the level of affordability at the time the notice of intent is submitted vests the application at that affordability level. So, for example, if a jurisdiction's determination changes during the application review process from a 10% to a 50%, or vice versa, the project is locked into that affordability level at the time the notice of intent is submitted. In addition, the labor section has been revised, but that ultimately just matches the statute. So now I'll turn it over to Harrison from our data and innovation team to go over the updated SMAP determinations. After Harrison's done with his presentation, we'll move into our public comment section for the guidelines update. And then when we're done with that, we'll transition to our Q&A for the updated SMAP determinations.
Thank you, Jessica. The next slides will be discussing the streamlined ministerial approval process and the current results of this year's determination, like we have in prior SMAP webinars. However, due to changes from SP 423 a few years ago, the determination is no longer static and can change throughout the year. Last year, HCD built a new SMAP dashboard, which can help track these changes throughout the year. And we will also be spending some time today giving a demo of the dashboard. Next slide, please. So how does HCD determine the jurisdictions where SMAP streamlining is available? First, HCD is looking at whether the jurisdiction has submitted the most recent APR. HCD also looks at the progress that the jurisdiction has made towards its RENA. The jurisdiction is halfway through the RENA cycle. HCD staff is looking at the number of units reported on APRs covering the first half of the RENA cycle. If the jurisdiction has completed one RENA cycle, but is not yet halfway through the next RENA cycle, HCD staff is looking at the number of units reported on APRs covering all years of the most recently completed RENA cycle. HCD staff also looks at whether the jurisdiction has a compliant housing element. For any jurisdiction in the 6th housing element cycle without a compliant housing element, they are now required to process qualifying housing developments with 10% affordable units on a streamlined basis. Any jurisdiction in the 7th housing element cycle without a compliant housing element by the housing element deadline is now required to process qualifying housing developments with 10% affordable units on a streamlined basis throughout the planning cycle. If a jurisdiction has not demonstrated sufficient progress towards the above moderate RENA, or has not adopted a housing element in compliance, or in compliance by the deadline for those jurisdictions in the 7th cycle, or has not submitted the most recent APR, the jurisdiction must permit qualifying multifamily developments on a streamlined basis if they have 10% or more affordability. If a jurisdiction has met their above moderate income RHNA, has adopted a housing element in compliance, or in compliance by the deadline for those jurisdictions in the 7th cycle, and has submitted their most recent APR, but has not demonstrated sufficient progress towards their low or very low income RHNA, they must permit qualifying multifamily developments on a streamlined basis if the development has 50% or more affordability. If a jurisdiction has submitted their most recent APR, has adopted a housing element in compliance or in compliance by the deadline for jurisdictions in the 7th cycle, and has demonstrated sufficient progress towards their very low, low, and above moderate income RHNA numbers, they are exempt from SMAP. Here we have a couple of examples of developments that could be eligible for SMAP streamlining. The first development is a for sale development, which could be eligible in a jurisdiction on the 50% list. You can see there are 500 total units in the development, 250 that are affordable to low-income households for a total of 50% affordable units, and it meets the labor and location requirement. The second development is a for rent development, which could be eligible in a jurisdiction on the 10% list. You can see there are 100 total units in the development, 10% of which are affordable to households at or below 50% of area median income. 5 of these are extremely low income units and 5 are very low income units. This one also meets the labor and location requirements. Next slide, please. For last year's determination, HCD staff built a SMAP dashboard to present each year's determination and show how it was arrived at. The goals of this dashboard are to improve on previous determinations by incorporating real-time housing element compliance, replicate features of the prior determination documents, such as the MAP, methodology, determination summary, and APR data summary, and to provide interactive navigation to find information more quickly. This is what the dashboard looks like, and we will now show a quick video walking through how to use the dashboard.
The main dashboard page is a summary of the SMAP status of each jurisdiction, which was previously found in the determination summary document, along with how that status was arrived at. From left to right, we have the jurisdiction name, the part of the planning period being evaluated, the period covered by the partial or full planning cycle being evaluated, when the evaluation period is going to change, whether the very low income, lower income, and above moderate income targets were met, whether the most recent APR was submitted by the deadline, the housing element compliance status for jurisdictions in the 6th cycle, whether the jurisdiction adopted a housing element in compliance by the statutory deadline for jurisdictions in the 7th cycle, and finally, the SMAP status of the jurisdiction. If you are a developer trying to see if a jurisdiction has to use streamlining on your project now that housing element compliance has changed, for example, you can select a jurisdiction in the drop-down menu and see the SMAP status of that jurisdiction. You can select Alameda and see that it's on the 50% list. If you are an advocate or someone else interested in the statewide statistics for 10% and 50%, you can look at the pie chart below to see real-time statistics on the percentage of jurisdictions in each category. This information previously could be found by consulting a combination of the methodology document, pie chart, and map, which were separate documents. So the goal is to bring all of this into one place. HCD still publishes a simplified version of that methodology document to provide additional information for interested parties. There are also drop-down menus for easy navigation. So if you were interested in a regional perspective, you could select multiple counties to compare across jurisdictions. If you wanted to look at the Southern California region, for example, a user could select Imperial, Los Angeles, Orange, Riverside, San Bernardino, and Ventura counties, and see the SMAP status by jurisdiction for the region. This data is updated daily with housing element compliance. The next 2 pages are for users that are interested in digging deeper into the data. Staff or the public previously would have had to download a spreadsheet for this. The first page is the determination summary page, which summarizes permits reported by jurisdiction for the period evaluated in the SMAP determination. The second page is the determination data page, which shows permits reported in each APR. The final 2 pages are the data sources and definitions used in this dashboard.
Having described the dashboard, let's discuss the results of the 2026 SMAP determination. As of yesterday, 32 jurisdictions are exempt from SMAP, a decrease of 8 jurisdictions since this time last year. 177 jurisdictions are subject to SMAP for qualifying developments with more than 50% affordability, a decrease of 24 jurisdictions since this time last year. And 330 jurisdictions are subject to SMAP for qualifying developments with more than 10% affordability, an increase of 32 jurisdictions since last year. This is based on approximately 95% of jurisdictions submitting APRs for 2025. Great job to those jurisdictions that submitted APRs and permitted more units. For those that haven't, SMAP is a strong incentive to submit your APRs and permit housing units. HCD uses APRs to track the jurisdiction's progress in implementing their housing element. This is a screenshot of the APR dashboard. This particular section displays key metrics derived from APRs, including use of SMAP by jurisdiction. Links to the dashboard will be provided in the Q&A section. Now I'll pass it off to Jessica.
All right, so now we'll transition into our public comment period for the guidelines update. And as a reminder, we'll take any questions related to the updated SMAP determination and dashboard after collecting public comments related to the guidelines. So just so everyone's aware, we will allot about 35 to 40 minutes or more if needed for public comments. Before we get started on public comments, recall from the beginning of the presentation that the type of comments and feedback that we're really hoping to get are those that are really within our scope. So remember the big picture. What would you love to see clarified in the guidelines, not what would you love to see changed about SMAP? In addition, your feedback can take the form of identifying a clarification that you think is just wrong, that we just missed something, or maybe we made a mistake. It could be something you've heard mentioned today, or if you've already reviewed the guidelines and noticed something, it could be that too. You can also offer up your own clarifications, and even better if you're able to point to where in the guidelines you're looking when you do that, that would be helpful. So the more specific you can be, the better. You can also think about the way the document's organized or any tables that might be helpful. So with everything that you've just heard in mind, when you go to give your comment, just take a moment to please consider if it falls within the scope that we've laid out. Again, some topic areas you might want to consider, but are not limited to, are those core components of the law, things like site eligibility, affordability requirements, review process, definitions, or anything else you've encountered as you've implemented the law. And I'm going to turn it over to, before I turn it over to David, just remember when we say public comment, what we mean is that you'll provide the comment, we'll listen to it. Again, we're recording this and we're going to take it in for consideration following this webinar. If it makes sense to do so, I might add a brief commentary after completion of the comment, but for the most part, we will continue on to the next person after your comment's provided to make sure we can give people who want to speak a turn to do so. So now I'll pass it on to David, who will walk us through about how we'll run the public comment.
So for public comment, you can use the raise hand button to get into the speaker queue. The queue will automatically have names arranged in the order that your hand is raised. You will have 2 minutes to provide your comment, and then we will have to move on. You can raise your hand to get back in the queue if you didn't finish. Once your time is up and your comments have been provided, we will transition to the next person. Comments provided in the form of a question will still be treated as public comment. And finally, please state your name and the organization or agency that you are from before providing your comments. This will be helpful in case we need to follow up with you after today's webinar. So let's get into it. Let's see. We have 2 people with their hands raised. So first off, we have Ruby, followed by Robert. Sorry, can we get someone to unmute them? Okay, Ruby, you should be able to. Hello, yes, we can hear you. Excellent.
Okay, thank you, thank you. Hello, good morning. My name is Ruby Toralva Pio. I am from Kings County. I'm a disabled and housed parent, and I'm commenting on the ACD's draft guidelines regarding SMAP determinations and SB 35 streamlining. I want to be clear, the purpose of the streamlining housing approvals is important. However, expedited approvals cannot become a substitute for accountability. The current framework appears focused on permitting timelines and approval velocity, but it does not clearly establish enforceable mechanisms to verify that approved housing is actually delivered, occupied, accessible, and compliant with legal obligations. When jurisdictions fall into the 10% and 50% categories that trigger SB 35 ministerial approval under Government Code Section 65913.4, the process becomes faster, but the question is, what accountability is triggered after approval? Where the requirements for unit level verification showing that these developments result in completed and occupied housing units, affordable units being provided to the population and income levels promised, compliance with disability access and reasonable accommodations obligations under the Fair Housing Act, Section 504 and ADA Title II, and Government Code Section 11135. These civil rights obligations are not optional policy goals. They are affirmative legal duties. Additionally, where federal funding is involved, federal grant requirements under 2 CFR Part 200 require appropriate monitoring, internal controls, and oversight of subrecipients. Streamlining cannot function as a pathway around fiscal responsibility or civil rights compliance. If SMAP determinations are designed to accelerate approvals, then accountability mechanisms should accelerate as well. My question is, what specific enforceable monitoring, reporting, and corrective action mechanisms in this framework verified at the unit level that SB 35 approved developments produce the accessible, affordable, and compliant housing that was promised, not simply faster approvals? Thank you.
Okay, so the next person in the queue is Robert, followed by Michelle.
Hello, can you hear me?
Yes, we can.
Okay. My name is Robert Embry. I'm the founder and principal systems architect for Reenlist to Life, and we're currently underway for a 32 resident facility in 29 Palms. My question specifically is regarding the public comment trigger, which is a unique feature added by SB 423. The project we have underway derives its use by right mandate from AB 2162, specifically Government Code 65651 and Home Key Health and Safety Code 50675.1.5. I'm trying to assure that the SB 423 public meeting rule does not apply to a development project that is using this use by right mandate. And that's my comment.
Hi, Robert. It sounds like you might have like a project specific question. Is that right?
Well, I mean, it could overlap multiple projects because we're about to start a second, but I want to make sure that we're not triggering this SB 423 public
Yeah.
meeting.
So there is a link in the chat to submit any questions like that to our housing accountability unit portal. So you might want to just maybe throw your question in there, and I think someone from HCD might be able to help you out with that.
Okay, I will do so. I thought this was a site eligibility topic, so I didn't mean to waste anybody's time.
No,
I'll
no,
send
you're
the
fine.
I'll send the email. Thank you.
Hmm.
All right, next speaker, let me take a look, is Oliver.
Hi, can you hear me?
Yes.
Great. Hopefully this is quick. Oliver Baker with CIM Group. An issue we run into with a lot of these state laws that talk about an 85-foot trigger for certain elements is lack of clarity about how to define 85 feet. Is it a zoning designation, a building code designation, from grade, from adjusted grade, and hoping that at some point we can get some uh, more guardrails around what the 85 feet means.
Thanks, Oliver. That's helpful. We'll see if we can make clarifications in the guidelines for that.
Great.
All right. Well, while we wait for more people to raise their hands, I did want to call out two questions in the chat. So one question from Alex who asks, on the dashboard, it says, except for San Francisco, each of the jurisdictions' determination will be updated at the completion of the first half of the RENA cycle and again at the end of the RENA cycle. But the presentation made it sound like this is updated daily. Can you clarify? So that was the first question. The second question is from Ruby asking, will my question be answered?
To answer the question about uh, uh, the dashboard being updated daily versus SMAP determinations being updated at the middle and end of the planning cycle. The way the SMAP statute is written, the eligibility for 10% list streamlining is based on the housing element compliance at the time of application submittal. So if a jurisdiction's housing element is out of compliance, then projects in that jurisdiction, qualifying projects in that jurisdiction, are eligible for streamlining if they have 10% or more affordability. So even though the number of even though RENA progress is updated for most jurisdictions at the middle of the planning cycle and at the end of the planning cycle, the housing element requirement is based on the housing element status on any given day. So that's the part that gets updated daily. Hope that answers your question.
All right. So to Ruby's question, I did want to make sure that we had like the opportunity to like make it clear as to whether we would answer that or not. I know a lot of it was structured as a comment, but I think to the specific question of what specific enforceable monitoring, reporting, and corrective action mechanisms in this framework verify that SB 35 approved developments produce the housing that's promised and not just faster approvals. Can we get an answer to that, or just like generally state a particular reason why we're not directly answering it at this time?
Yeah, so Ruby, I just want to reiterate that the purpose of today's webinar is just to collect comments. And I did mention previously that any questions that we do receive are going to be treated as a public comment. So we'll take everything in, and after today's webinar, we will address all comments and questions. And you should we'll publish that and you'll see a response to all of the questions and comments that are received today.
All right, so we have one person with their hand raised, which is Matthew, and you're free to ask your question once you are able to unmute yourself.
Hi, David. My name is Matt Cody. I'm with Best Best and Krieger. I think we've spoken before. Thank you for the presentation. My question relates to the process for submitting public comments and understanding kind of where the information about you know, submitting them and how this process will unfold. It sounds like there's an opportunity to submit written comments. It's not clear to me how that would be done from HCD's website. So I'm hoping that that information can be provided here or on HCD's website. And then if we could understand, um, you know, what additional process might be available for comments, and kind of how that is being determined, and if that information can be made available on HCD's website, that would be helpful. I personally had to kind of struggle to find out where this webinar was, how to register for it. So it's just kind of a request and a comment that the process for reviewing and approving these guidelines, if that information could be provided on the HCD's website, that would be helpful. Thank you.
Thanks, Matthew. There's in the chat, we dropped the email address where you can email comments to, public comments to. And at the end of when we wrap up the webinar today, I'll provide some information on where to sign up for getting emails for all of the notifications that come up from HCD.
And I see the chat being disabled, so I don't see that information.
Are you able to see any of the links that David posted, or is the chat box completely disabled?
I don't see any links on my end.
Let's see if John can help out with enabling that.
Hi, yes, Matthew. Go ahead and click the chat bubble on your panel, and if it's not there, click on more, and you should be able to see the chat panel.
I do not see it still. I do think generally it would be helpful to have the email for submitting public comments posted to HCD's website. Otherwise, I'm not sure how that information would be generally available.
Yeah, we also have multiple people now in Q&A saying that chat is completely disabled for attendees. So I don't think they would have been able to see the message that I put in there. So apologies for that. We'll try to find the solution to that and also potentially follow up over email to make it so that you have the links in the end.
Thank you.
All right. So as for the rest of the Q&A, we have one question from Marnie asking, why would the housing element status change on a day-to-day basis? And then a second question from Carl saying, how is the middle of the RHNA cycle defined?
Barry, did you want to take the housing element status change, or would you like me to take a stab at that?
Are you able to read the question? I don't see that one. Sorry.
No, yeah, it says, why would the housing element status change on a day-to-day basis? So, I mean,
Yeah, I can take that. Yeah, thanks. Basically, jurisdictions' housing element due dates vary based upon what region they're located in. There are also um, jurisdictions will at times revise housing elements. So a housing element status could change on any given day depending on when that jurisdiction submitted their housing element for HCD review and the results of HCD's review. So a housing element letter um, could go out in any day, and the dashboard would be reflected would be updated to reflect that, and it is updated daily based upon housing element compliance status in HCD's database.
Yeah, I do want to add too, if there's enforcement actions done, like if a local jurisdiction um, does anything or acts or there's not an inaction on any of their housing element programs or anything else going on, HCD could also revoke housing element compliance. So that's also another reason why it's updated daily as well. Harry, there's another question about how the middle of the RENA cycle is defined.
So for a jurisdiction that's on an 8-year planning period, that's the middle of the a jurisdiction reaches the middle of the RENA cycle after they have submitted the first 4 APRs of the RENA cycle. So annual progress reports covering the first 4 years of the RENA cycle. After they've submitted the 4th APR of the cycle, that's when they'll be evaluated for progress towards half of the RENA for the purposes of the SMAP determination.
All right. Well, we don't have any hands raised at this time or questions in Q&A. But if you do want to share anything else, you are certainly still free to do so. Robert asks, was this webinar only to evaluate the dashboard?
So I'm a little unsure about that question, but so the purpose of today's webinar was to collect public comments on the SMAP guidelines update and also just to provide a brief overview of the updated SMAP determinations based off of the latest APR data that HCD's received, and also just provide a brief overview of how the dashboard works. I don't know if I answered your question, Robert.
We have another question from Marnie who asks, can your SMAP status change solely because you failed to submit your APR?
Yes, it can. So there are 3 reasons that a jurisdiction could be on the 10% list. One is that they have made insufficient progress towards their above moderate RENA in the applicable, as reported in the applicable APRs. One is they haven't submitted their most recent APR by June, and the deadline is April, so there's a bit of a grace period there. And the third reason is not having their housing element in compliance for jurisdictions that are in the 6th cycle, and for jurisdictions that are in the 7th cycle, the the housing element requirement is in compliance by the statutory deadline.
We have another question from Markham who asks, SMAP indicates the inclusionary units are to be counted toward the SMAP requirement. However, it would be nice to know if the inclusionary percentage can go beyond the SMAP 10% or if a developer could just provide 10% and ignore the locality's higher inclusionary requirement.
Thanks, Markham. We'll note that for the guidelines update. Any other comments on the SMAP guidelines update or any questions for Harry related to the updated SMAP determinations? I'll give everyone a minute or two. All right, well, seeing none, we can move on. Just as a reminder, we'll continue with the public review period through July 20th. So you can go back into the guidelines and send us written comments to the email SB35 guidelines comments at hcd.ca.gov. That email is in the chat, and I'm hoping that's enabled now. And if we do make substantive changes, look out for a possible second 15-day public review. And once the draft is updated, we'll publish a summary of all the comments received and responses to each comment, indicating how or if it has been addressed or incorporated or not. So we were supposed to have the Q&A session for the determination and dashboard, but that kind of evolved into like a one thing. So we'll move on from that. So I guess to Matt's question earlier, if you want to get emails when HCD makes announcements, you can sign up for emails at hcd.ca.gov and click email sign up. So you'll receive all of our e-blasts and anything that comes up. And then you can also follow us on Facebook, X, and LinkedIn. And then HCD is also hiring. You can look for jobs at jobs.ca.gov. And here's this last slide with all of the links that we talked about today. Again, you do have until July 20th. if a lot of people have had issues in trying to figure out where to provide comments, we could extend that a little bit longer as well. But yeah, lastly, thank you all again for attending today.
Thank you for attending the webinar. This is now concluded.